Liebenberg.
Good morning, CJ. Lovely to be here. Thank you.
How are you?
I'm well, surprisingly.
Good.
I noticed the Premier walked out as I came in.
No, that's all right. He'll be back.
He'll be back.
Yeah. Will he be back, AJP? Let me not make assumptions.
Yeah.
I thought he went to get tea or to the bathroom.
I also assume that he'll be back. He didn't say anything.
These things are
He's
still
back.
there.
He's
Oh,
back.
there he is. Okay. Your application form says you were born in 2072. When exactly were you born?
I realized that this morning as I'm reading it. And yes, in fact, I was born the 24th of November, 1972.
I thought that might be the case. The person who typed this form for you didn't do you any justice. I picked up a few other typos, but this one was rather startling.
Indeed.
All right. You hold BA honors and LLB from what used to be Rao.
Indeed.
And you started out as an attorney.
I did so, yes, CJ.
And you did your articles with 3 law firms and you explained how that came about.
Yes.
And at some stage, you practiced as an attorney for how long?
It was for 2.5 years.
2.5 years.
Yes.
Okay. And then decided to join the bar.
Yes, that was in January of 2000. I commenced my pupillage here at the Johannesburg bar.
Yes. And you mentioned that you switched chambers. You started somewhere, then ended up with Group 21.
When I started, I was one of the last intake when the bar was really still in town, and I took chambers up in what was Innes Chambers, what is now the NPA's building.
Yeah.
Which was wonderful for a baby junior who could run across the road and do what needs to be done by way of postponements or noting judgments.
And you've practiced as an advocate since 2000?
I've been in practice throughout since 2000, yes.
And what kind of work do you do?
At present, as I indicated in my questionnaire, over the 25 years at the bar, my practice has evolved to, I would say the latter half of it is mainly within the context of family and matrimonial work, where it became a specialized practice.
Yeah.
Not because I chose it, but because practice chose me. I enjoy it. I enjoy it.
Yeah, that kind of work chose many women practitioners for some reason.
Yes, indeed.
You also have, you've undergone mediation training.
I did. It was a 20-hour course I did in 2013. And pursuant to that, I assisted with FAMSA, the Family Life Centre in Johannesburg and Parkview, mediating, which I did for a couple of years, but I found the co-mediating module and method that they followed, it didn't suit me.
Is it a skill you apply a lot in your practice?
Sorry,
Is it a skill you apply frequently
Oh,
in your
absolutely.
practice?
Oh, absolutely. Within the context of family law, I regard it as my professional duty to rather find consensus-based solutions than advocating for litigation. It is simply too traumatic for both litigants, but if there are children involved, more so for them, so that one has to mediate insofar as it's a mediation, but find common ground and settle a matter.
You started acting as a judge in April 2020.
Indeed,
in Johannesburg.
in Johannesburg.
That was during the COVID lockdown.
Uh, it was a baptism of fire, CJ.
Yeah.
I remember so well, my registrar, we managed to meet each other so that she could hand over to me the hard copy files, because she was still unsure about case lines. I learnt about case lines there and then, for which I was eternally grateful. And it was very peculiar, and it was really the first time having to hold court online, sitting in my study at home,
Yeah.
with young children in the background, and having to tell them to keep quiet because mom's working.
Yeah. Interesting time that was.
We survived it.
Yeah, we did. How long was that acting stint?
That was, initially I did only a week at a time pro bono. I did 3 of those stints, and then since, let me just see here, what was it, in June of 2024, I took on longer stints, and it became stipendiary appointments, so that as I sit here today, subsequent to completing my questionnaire, I now have 29 weeks of acting under my belt.
All right. And during that time, in which courts have you had occasion to sit?
It is, at the time of finalizing the questionnaire, it was only in the civil courts. I sat in civil trials, opposed motions, unopposed motions, full court appeals, full bench civil appeals. I did say urgent court, unopposed divorces. Yes, and then subsequent to mid-June, in the last stint I had now in the 3rd term, I had occasion to sit also in criminal appeals, both in a full court criminal appeal and then a full bench criminal appeal.
How many criminal appeals have you done?
Well, I read 3 and we heard 2.
Have you sat presided in a criminal trial?
Sorry?
Have you presided in a criminal trial?
I've never presided in a criminal trial, no.
Have you done criminal work in your practice?
In my practice, no.
Okay. You've also attended the advocacy training course.
Indeed.
What was the purpose of that course?
The purpose of the course was to train me to be a trainer for pupil members, and to train the pupil members in what is termed the method, which is an international renowned and accepted methodology of training young advocates and pupil members in practice, in advocacy training.
Have you trained any pupils?
Yes, indeed. I've had 3 pupils myself in the 25 years. I'm very proud of them. They are doing exceedingly well. 3 ladies. I have also then, in the context of the group itself, we're a very large group with very many young members, advocates, and it's been a pleasure also to assist them both in informal lectures, but then whenever they knock at my door, they must come in and come ask advice, and I readily give it.
All right. How many judgments have you written?
CJ, as I sit here today, I have written 50 of them. I have 6 that remain out reserved since my last stint, 3 of which are in the context of appeals. I'm waiting for 1 where I'm the scribe, 2 I am the scribe, 1 I'm waiting for comments from my co-judge. But yes, I have written 50 judgments, written judgments.
Any of them reported?
None. They have been, some of them are available on SAFLI and other online libraries, but nothing in the printed law reports, no.
The ones you say are reserved, when were they reserved?
I reserve judgments, if you will allow me to put on my eyes. The oldest reserved judgment, if I can call it that, was an opposed motion that I heard on the 26th of August. And I'm putting the final touches to my judgment.
That's the oldest you say?
That's the oldest of the 6, yes.
All right. All right. AJP?
Thank you, Chief Justice. Advocate Liebenberg, good morning.
Good morning, AJP.
I note that you've practiced for about 25 years.
Yes.
And mainly on matrimonial matters.
Indeed.
And in the questionnaire, you asked how often do you appear in court? You say occasionally. If you can indicate in the 25 years when you say occasionally, how many times you appear in court in a year?
I generally appear at least 2 or 3 times per month in court. I regard that as occasionally at this juncture. There were times where, as a young advocate, I was in court nearly every day of the week in unopposed court. That's simply not so anymore. I do far more chamber work, far more drafting work. That is the preparation of affidavits for then to argue then. So I would say about 2 to 3 times a month.
You indicated that you've never sat in a criminal trial and that you sat in criminal appeals.
Yes.
How many appeals, criminal appeals, did you sit on?
We had rostered, there was one full court appeal that I sat with very seasoned criminal judges and seasoned in criminal law. And then I sat, we had 2 full bench criminal appeals, of which one was postponed on the morning of the hearing. So we heard just the one.
Were you a scribe in any of those matters?
I am a scribe in one of them, yes.
And the judgment is still outstanding? It's
still outstanding. I'm awaiting comments from my co-judge.
Okay. Another aspect in paragraph 11 of the questionnaire, when you were asked to talk about your health.
Yes.
Since it's a public have access to these proceedings. CJ, can I read out what she stated?
I have absolutely no objection.
Okay. Yeah, you say in 2007 you were diagnosed with bipolar mood disorder and general disorder.
Anxiety disorder, yes.
Anxiety disorder. Can you maybe explain to this commission as to what is the situation now? Now you're coping?
Since 2007, I have been receiving treatment by way of medication. I see my psychiatrist twice a year. As and when needed, I see a therapist. But that has nothing to do per se with the bipolar mood disorder or the general anxiety disorder. I believe that there is no reason for me to be ashamed of the conditions. I'm very fortunate in that my condition has been 100% stable. I have never since 2007 missed a single day's work because of it. Other people are not as lucky. But I am very fortunate. And I can and I do cope with it as some people cope with high blood pressure. or a heart condition or diabetes. It is treatable, but one has to be compliant, which I am.
With the workload in Gauteng division, as you've only acted for 29 weeks, do you still think that you'd be able to cope if you are recommended and appointed?
Absolutely, I have no doubt. It is, I don't think people who are not used to Johannesburg, I'm familiar with the Johannesburg court specifically, have got no inclination of the amount of work there is. And one has to do what one has to do when you have to do it. There is one opportunity to read. You must read for meaning, you must be prepared. I have coped, I think, exceedingly well. There were times where in the last stint it was somewhat overwhelming because I was pulled in at the last moment to assist in a post-motion court, so that I had 2 opposed motion court weeks within 6 weeks. It took a lot of work and a lot of effort, but it's possible, absolutely.
Yeah. As much as we've got a family court, and you've also indicated that you've been working with matrimonial matters for some time.
Mm-hmm.
But in Gauteng, you've got to be able to cope with other works like criminal work, or post-motion, etc. Mm-hmm. Did you have an occasion to deal with criminal bail appeals?
No, not yet. No.
Have you been allocated any petitions where leave to appeal in criminal matters?
No, I have not. It was simply a manner in which I was rostered, whether by the DJP and the then JP. I've just never been rostered into the criminal courts. Also within Gauteng, specifically Johannesburg, judges are rostered for an entire term in the criminal court. And I have not acted an entire term for 9 weeks on end at any time.
Yeah, we don't roster judges, especially in respect of automatic reviews. Thank you. Yeah. My last question, in respect of the automatic reviews, mm-hmm. because they're just allocated to all the judges, did you get an opportunity to deal with those automatic reviews?
No, I have not.
Thank you, CJ.
Premier?
Thanks so much, CJ. Good morning, Advocate Liebenberg.
Good morning, Premier.
Advocate, Gauteng is a cosmetic province that incorporates literally all constituencies. Mm. Informal settlements, townships, hostels, farming communities, suburbs, and all other constituencies.
Yes.
And I've gone through your profile. I've never seen an inch of understanding of all these constituencies that you may need to understand when they appear before your court. Am I right or wrong?
Sorry, I'm not following, Premier. I haven't seen what?
I'm trying to get your understanding. I'm saying Gauteng, you know Gauteng have all these constituencies.
Yes.
I'm trying to understand that if these constituencies appear before you in court, mm-hmm. will you have a better grasp of understanding their background and understanding their needs?
Well, Premier, in my practice, I have had occasion to interact with people from a variety of backgrounds. I have had pro bono clients from informal settlements. I have had clients living the most extraordinary life I was fortunate in court itself. I have had occasion, reference is made, is it in Judges Matters, I think, a judgment I wrote where I was not prepared to authorize, in terms of Rule 46A, an executability order against somebody's home, because I regarded the amount owing as too trivial to allow a home to be sold in execution. Attached to my bundle is a judgment I wrote regarding an interim interdict against the background of the National Feeding Scheme, Scholar Feeding Scheme. And to me, given what that feeding scheme is intended for, and it is intended to feed those children in quintile 5 schools who are unlikely to have any other meal of the day. That weighed very heavily on my mind, and in the exercise of my discretion, that was a factor. So that I do believe that I'm fortunate enough and empathetic enough to understand how fortunate I am, as opposed to so many others out there in Gauteng, the cosmopolitan province that we are.
Thanks for that, but if that was too close to your heart, when you are asked about your community involvement here, this will be high on your list of community involvement and pro bono work that we've done before. But what you've just beautifully explained to me is not tabulated in any of your documents.
Sorry, Premier, the judgment is...
Not the judgment. You said you've been doing pro bono work in informal settlements.
No, I did not say I do it in informal settlements. I said I do pro bono work, and some of my clients came from informal settlements. So that an institution such as probono.org would ask for assistance. I've had occasion where some of the larger attorney firms in town have a very specific department dealing with pro bono work, and I've done work with those firms, and it is for people who come out of backgrounds that I cannot even imagine.
I know you served in the school governing board.
Yes, I did.
Of large school Unica.
Yes.
And in most instances, were responsible for the policy formulation of that document.
Yes.
Will you say that there are documents that promote access and transformation? And what is the status of this school now in terms of representation of other races?
Well, I haven't been part of that governing body for some time. It is an Afrikaans primary school, formerly Model C school. I'm very proud to see more and more darker complexion children attending that school, because it's a very good school. But yes, it is an Afrikaans primary school. But the school is far from absolutely representative insofar as race is concerned, and no doubt because of the language of instruction.
But you served there for 3 years.
Yes, I did.
So for 3 years, you didn't see the importance of expanding the scope of the school to incorporate everyone?
Well, when I formed part of that school governing body, what was uppermost important at the time was that school running with COVID and the lockdown, and what we did for purposes of ensuring that all the children in the school, also those that come from less fortunate circumstances, were able to receive education online by way of Google Classrooms. We were able to source tablets, data, and assist families who were less fortunate to also ensure that those children were able to attend school online.
Thanks so much, CJ.
Thank you.
Yes, JB?
JP.
Advocate Liebenberg, I'm just concerned with your choice of word, describing people by their complexion. When you say darker complexioned children, who are you referring to?
Africans, JP.
Is that a proper description by the looks and the appearance?
Well, the question was whether the school was representative of the society.
Yes.
And the answer is it's an Afrikaans school with mostly white children. But yes, they are, and more I see, simply because I live across the road, I see the little faces that come to school. And it's African children, and African as in the broader definition of black, colored. I think there might be some Indian children, but it is an Afrikaans school.
Yes, but collectively you say darker complexioned. That's my real concern. You now explained it differently.
Yes, I mean no disrespect.
Thank you.
I choose not to think in terms of race because I think we're all the same.
But that's exactly blankers and knee blankers. This is what used to be. Even all the science used to be framed that way.
I
Thank you.
apologize. My choice of words were
Thank
wrong.
you. Yes.
Commissioner Hassan, it is a follow-up.
It's related, it's not exactly a follow-up.
Okay.
Ms. Hassan.
Thank you, Advocate. I guess it's somewhat related. Across the 25 years of your practice, you've mentioned here that you've only had 3 juniors.
Yes.
Let me understand first before I probe my question. What was the demographic of the juniors?
They were all all African.
And do you think that 3 juniors in the span of 25 years is sufficient?
In the context of family law, regrettably, that's the reality.
Did you take any proactive steps to actually gain juniors?
In the context of family law, Ms. Hassan, perhaps I must just preface, the juniors I had in 2 matters were in fact commercial matters. It was insurance matters. There was 1 black junior I had in a family law matter. Family law, regrettably, I deal with individuals, and litigation is expensive. So that it is the type of work that I've received, the attorneys that brief me, very rarely do clients have the financial wherewithal to pay, never mind 1 advocate, but far less so 2 advocates.
Maybe before we get to the fee splitting, Advocate, are you saying that you didn't see the need to have black advocates because you had a family law practice? Or black juniors, rather?
What I am saying is that my practice and the type of work that I received.
Now, I recognize the type of work that you've received. When we're trying to understand the level, you want to be ascended to the bench. Briefing juniors is not just a matter of compulsory work, it's part of the transformation. And one of the challenges that keeps coming up, not only in this body, but in the industry, is the briefing patterns are extremely problematic. There are spaces of law in which young black juniors just do not get briefed. Are you then saying you did not brief black advocates by virtue of the fact that they were family law? Let's leave the fee split in a moment, we'll get there.
Well, Ms. Hassan, as counsel, I do not brief advocates. My attorneys brief advocates. Attorneys brief them. What I
No,
would do.
what I'm
what I-
asking is you didn't see the need to bring on black juniors onto your work.
Not in the matters I had, no. There were no space for any junior, black or white. It was simply not the type of matter that required two. But what I did do is the moment that a matter would come my way, and there were parts of the brief that did not require my attention as a more senior practitioner, I was very happy to give the names of colleagues in my group and elsewhere, black juniors, to do that portion of the brief.
All right, and then just before I yield back to you, Chief Justice, I'm interested to know on the fee splitting agreement. You indicated that the reason why you didn't bring on black juniors was because of fee splitting issues. Maybe you could explain that to us?
No, it's not about fee splitting, Ms. Hassan. Regrettably, as I've indicated in my questionnaire, working for individuals, I could never charge the rates, for instance, that commercial colleagues may do, because I work for individuals. And that was part of what I thought my way of giving people access to justice was to work at reduced fees so that people still battle to pay, and then to expect them to pay for two counsel becomes virtually impossible. So that I was only ever in a family law context, junior in 25 years, perhaps twice or three times, and then only for little bits of the entire matter. Because even those people with financial wherewithal have difficulty in paying the costs of litigation. It's incredibly expensive.
And have you taken any concrete steps to change briefing patterns in your bar council, in your group, anything related to that?
Yes, as I mentioned, I make a very specific effort to, when my attorneys call for names of juniors who may attend and can attend to matters, to refer them to black juniors. Absolutely. Men but more so females.
Minister? Okay. Oh, before Minister, the follow-up? Okay.
Unless the minister is also following up. No. Advocate Liebenberg, the advocates for transformation, you know who they are.
Yes, indeed.
Yes. They say that you were a vociferous opponent of the three council rule. Is that correct?
Commissioner Katobi, I was taken aback when I read that. One, as I recall, that rule was adopted at the annual general meeting of the society in October of 2015. I was not at that meeting. I'm not opposed to transformation, but I may have raised questions in a different fora, whether it was in the common room in the group, as to the methodology of the implementation. But then as advocates, we very rarely agree with each other as to how to do things. But no, I was not a vociferous opponent, no.
And what was your concern about the methodology of implementation?
It's 10 years ago. I do not have independent recollection. I think it was, my biggest concern was probably mindful, again, my perspective from my practice as in family law, it is exceedingly difficult to pull in a junior, much less three. That there are three advocates on a matter. And I was concerned about, it might be that, I really do not have any independent recollection of what I may or may not have said, but that transformation is a must and an imperative stands. It's a universal truth.
What is the problem with your practice that disables you from implementing transformation?
No, there's nothing disabling me from doing that. It's simply a question that my practice does not allow the appointment, more often than not, of two counsel. Doesn't matter whether it's two juniors, whether it's a silk and a junior. It's difficult.
How does that apply to the three counsel rule? I'm struggling to understand why you are introducing your practice in relation to the three counsel rule.
I'm trying to answer it, well, as family law practitioner. To appoint two counsel is difficult. To then seek, more so because as I recall, the rule was aimed also at then regulating a compulsory aspect to the appointment, which may render a member guilty of unprofessional conduct if you do not do so.
Yes.
That became Rule 7.
Yes.
That is exceedingly difficult in a family law matter.
I'm struggling to follow. The rule says if you have three or more advocates, it's compulsory for the third advocate to be black. If you fail to do that, you're committing misconduct. What's the problem with that?
No, there's no problem with that. 10 years ago, there were debates about it. And I may have raised concerns in a common room situation at Chambers. I can't remember that I did.
But what were the problems you were raising in the common room at Chambers about this rule?
The implementation, how it will be implemented.
But what's the problem with implementing it? That's what I don't understand. What were you objecting to the implementation?
No, I wasn't objecting to the implementation.
What was
I
the
had
concern?
questions and reservations about it. That doesn't
What were
mean
the questions and reservations?
I cannot recall. I do not have independent recollection of 10 years ago. I'm sorry.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Liebenberg.
Good afternoon, Ms. Play.
As I understand your answers to both Commissioner Hassan and Commissioner Mbokai-Tobi, you've only ever had 3 juniors in your matters over 25 years of practice.
Yes, yes.
You've only led 3 times.
That's as I recall, yes.
And those were 3 specific matters.
It was specifically 3 specific matters, yes.
And all 3 times you used black juniors.
Yes.
And your explanation for not using more juniors is that your practice doesn't allow it.
Indeed.
Now, I know most established groups at the Joburg Bar have what's called a junior fund,
Yes.
where they allow their members to utilize that fund in order to bring on juniors onto their matters. Does Group 21 have such a fund?
Yes. Yes.
And
yes.
have you utilized that
No,
fund?
I have not.
Why haven't you utilized it?
I have experienced in court, in family law matters, not sitting on the bench, on the other side, the perception that it creates the moment that a litigant has more than one advocate. It creates the impression of there being more money than there really is. And that is it's a dangerous perception. And the perception is that of the presiding judge. And it does have an influence, regrettably, at times on judgments.
So is your true answer then that you chose not to bring more black juniors into your practice in order to protect your clients from an unfair perception?
In part, yes.
So why didn't you give that answer initially when you were asked about this?
I'm sorry, I didn't think of it initially.
Can I then take you to one of your judgments?
Yes.
It's the judgment involving 2 children
Yes.
who were engaged in a bullying environment. You recall the judgment?
Yes, yes.
It's got a difficult name. I think it's something like L versus
Yes, we
R.
had to redact the names.
Now, can I ask you to go to paragraph 50 of your judgment?
50. Yes.
Find it at paginated page 44.
Yes.
And in this matter, as I read your judgment, one of the issues was that the one child had at some point grabbed the testicles of the other child.
That was the allegations.
And the
yes.
other child considered that to be harassment, and that's one of the incidents that gives rise to the dispute, which is before you. Now, in paragraph 50, you say, and I'm picking up from the middle of that paragraph, you say, in the context of this matter, I emphasize that the conduct is unacceptable and requires censure. But there is no suggestion on the affidavits filed that the alleged squeezing, and I'm going to read into that squeezing of the genitals, was sexually motivated conduct. You say whether the alleged incident amounted to sexual harassment was not established.
Yes.
Now, I just need to understand, if you've got 2 parties and the one squeezes the genitals of the other, how does that not amount to sexual harassment?
In the context of this matter, we were dealing with 2 young boys. And it was an appeal, civil appeal, from the magistrate's court. The boys at the time, I'm just checking, 9 years old. So very much one of the aspects was whether or not these children were Dolly Kapaks.
Sorry,
And-
can you just repeat that word?
Whether these children or the alleged perpetrator were in fact Dolly Kapaks, whether they had the capability of being legally liable. My co-judge and I debated the issue. This was a single incident. There were substantial, it was 2 parents deposing to affidavits, the magistrate having made a decision not to hear oral evidence in the face of factual disputes. The reference to squeezing was in fact the word utilized by the one parent. And my co-judge and I debated the issue, and we were satisfied that on the allegations before us, that did not amount to sexual misconduct. These were 2 boys fighting. And there was a real concern as to whether, in fact, the alleged incident really took place.
You see, Advocate Liebenberg, I don't want to get into the weeds of that particular matter. I'm debating the principle with you now, which is a very concerning one, and I'm going to be frank with you.
With adults, we're talking it's something completely different. When it involves adults, that is sexual harassment, absolutely. But in the context of 2 young boys, my co-judge and I, we were not satisfied that it amounted to, for purposes of the act.
You had already addressed the question of capacity of the children separately in your judgment, and you had made findings in relation to that.
Yes.
You are on a different topic now, which is, does the conduct amount to sexual harassment? And you say there that it's not sexually, this is your word, the words used in the judgment, it's not sexually motivated conduct.
Yes.
Now, that's the difficulty I have. How does that square up with the definition of sexual harassment in the Prevention of Harassment Act?
I don't have let me just see if I have, if the,
Can I read to you what the definition says?
yes, I'm just trying, I think I may have quoted it, but yes.
A of sexual harassment, the definition of sexual harassment is unwelcome sexual attention from a person who knows or ought reasonably to know that such attention is unwelcome. The second one is unwelcome explicit or implicit behavior, suggestions, messages, or remarks of a sexual nature that have the effect of offending, intimidating, or humiliating the complainant. Now, you're finding that it didn't constitute what you call sexually motivated conduct. It's not clear to me how that squares up with the definition of sexual harassment. And I'm worried about what kind of principle we draw from your finding.
Well, it must be gauged with respect, Commissioner Pillay, against the role players here. Because if we are talking children who do not have the capacity to appreciate necessarily what their conduct amounts to, that does not fall within the definition of the Act.
But then why did you go further and make a finding on sexual harassment? Why didn't you end your judgment on these children lacked capacity?
As I specifically recall, my co-judge included this reference. We agreed. And I do recall that it was her comment, and I accepted the inclusion, the suggestion to include that. Because in the context of this matter, I similarly did not believe it to be sexually motivated conduct.
But you're coming back to the problem of sexually motivated conduct and what that could possibly mean going forward in terms of interpreting the Act.
Well, the judgment, with respect, and at the risk of repeating myself, there's a difference, a big difference, in when one deals with children of a specific age, behaving in a particular matter, and when one has children perhaps that are older, at a stage of maturity that one would expect them to know better, and when one deals with adults. That sentence should not, and with respect, cannot be interpreted to constitute a blanket principle when dealing with the Prevention of Harassment Act, because of the role players involved in this particular matter.
Not sure what cannot be interpreted, because I've just interpreted it that way, because what you're saying now is not reflected in your judgment to curtail that paragraph to the facts of the particular case.
I accept your interpretation.
Thank you, Advocate Liebenberg. Thank you, Chief Justice.
Thank you.
Thank you. Good afternoon, Advocate Liebenberg.
Sorry,
over here.
Oh, sorry, President.
Good
I hear the voice. I should have seen the hand. I do apologize.
Yes, that's fine. How are you?
I'm doing well, thank you.
I want to ask you a question, and the reason why I'm asking this question is that in response to the questions posed by the Chief Justice and the Acting Judge President, you indicated that you've never presided over a criminal trial.
Yes.
You haven't done petitions emanating from a criminal court. You haven't dealt with automatic reviews. You have had an opportunity of participating in a criminal appeal, but you have not yet written a judgment, or your judgment is still in the process of finalization. I'm sure you'll agree that criminal law is a very important area of the law because, I mean, as a judge, you can actually take away someone's freedom for
Absolutely.
life, which is a constitutionally protected right. And this is where my concern emanates from. And I am mindful of the fact that as an acting judge, or even as an ordinary judge, you don't allocate work to yourself, so you don't choose cases. But fact of the matter is that you haven't done any criminal work at this stage. How will this body be in a position to assess whether you will conduct the proceedings in accordance with the requirements of the law when you are allocated a criminal trial? Because in as much as you have never been allocated a criminal trial during all your acting stints, we can all accept that once you are appointed, you can't escape that you will be allocated a criminal trial.
President, it's something that concerned me, and I'd hoped to be rostered, and I asked to be rostered. It didn't happen. I must say I was surprised when, and of course I must learn. I'll have to learn. But I was very pleasantly surprised when I had to prepare for the appeals, and I felt so out of my depth. And then in our pre-hearing discussions, when I was asked questions and I gave the answers, that it's kind of a muscle memory that kicks in. Yes, there are nuances. Of course, there are nuances in criminal law as opposed to the civil law. But the muscle memory of what I was taught 30 years ago, what I learned for my bar exam, it's still there. And what I also found was in Johannesburg, the amazing collegiality. To be able to ask, I have a question, I have a concern, help me with my gut feel. I had an occasion, yes, in the context of a family court matter, but it was purely because it emanated from a Rule 43 order, where the respondent had been convicted of contempt of court, and the sentence was suspended on certain conditions, and he had not complied with those conditions, and what came before me was an application to set into motion that sentence. And I was able to talk to a colleague, a neighbor, and I was right, my gut was right, and I was quite proud of myself in realizing that no, I can't change the sentence. 14 days is 14 days, but I was able to craft an order implementing the sentence and send the man to the golf over weekends so that he was still able to work during the week so that he could pay his maintenance order.
Yes.
And that was, yes, there's a gap in my experience, and I accept that, and unfortunately there's very little I can do at this juncture about that gap.
Yes, thank you very much.
Thank you,
CJ,
President.
my second question, and it's related to the first. Two scenarios in a criminal trial. Under which circumstances would you order a separation of trials, and under which circumstances would you make an order for a trial within a trial? Thank you.
Thank you. Separation of trials would be where, for instance, if there are multiple accused, the one would plead guilty and the other not guilty. Then one would separate the trials. A trial within a trial is really a question on determining whether evidence is admissible or not. It's a question of the admissibility of evidence when there's a trial within a trial.
The question was, when would you make an order for that to take place?
Oh, sorry, the
The
trial within a trial.
Can you make an example? Thank you.
For instance, should an accused allege that a confession was somehow elicited unlawfully, be it under torture or threat or of some kind, then to ascertain, I would order a trial within a trial to determine the admissibility of that confession. Thank you.
Thank you very much, Advocate Liebenberg. Thank you, CJ.
Else, colleagues? JB?
It's me again. Just to follow up on the criminal trial experience.
Yes.
Often in criminal matters, especially at the high court level, you come across very serious cases. You have to look at post-mortem examination reports, which are quite gory, scary. Will you be able to manage to look, analyze these documents?
I see no reason why not, JP. In children's matters, when one has to read, it's not necessarily the blood and gore of photographs, but to read reports, expert reports. It tugs in places you don't want to be tugged, but you have to, and you analyze it for what it is. If I can avoid blood and gore, I would appreciate that. But that's not my job. My choice is not what seizes the day. One has to look at it. You have to consider it, and do so forensically, detached, in as far as possible.
But it does take some time to get used to this.
Of course
Otherwise,
it does.
it might have a serious problem.
No, of course it does. Well,
Thank you.
JP, that's family law. It's the old thing. Well, not an old thing, but it's trauma. It's traumatic, and one has to. And I think I've learned through family law and the trauma that my clients bring to me, and how to deal. I have to deal with it for myself. It's the similar skills that one then adopts within in criminal law.
Thank you, Advocate Liebenberg.
Thank you, JP.
Thank you.
Thank you very much, CJ. Good afternoon, Advocate Liebenberg.
Prof, good afternoon.
I was quite taken aback in relation to the issues of transformation that were taken up with you. In particular, earlier on you said that you were not comfortable, or perhaps the core mediation process did not suit you. And then it was revealed that at some point you had certain discomfort with a 3-counsel rule. When I look at these events, it creates a perception in my mind that brings up a question whether you are able to work within a team. Not because you are forced to, perhaps maybe you have certain appeals and all those kind of, because we don't know what really happened there. But it creates that perception that are you able to work and function adequately within a team, not because you are forced to, but because you are comfortable in doing so.
All right. In relation to the co-mediation model that I did not find comfortable, regrettably, it was the model is a legal practitioner and a mental health practitioner co-mediating, and it got to me that the mental health practitioners gave legal advice and did so wrong. They gave wrong advice. And I found it uncomfortable, and I was I didn't wish to enter into nastiness or have fights about it. So that was the discomfort there. When I say in relation to the 3-council rule, it was never whether or not there should or should not be transformation. It's a question of the implementation thereof. More so that I was, and I think back about what I may have found uncomfortable was to tell an attorney or tell a client who must or must not be briefed. Because I am so sensitive to who gives instructions, ultimately, and the role of advocate. But no, I work in teams. That's what I did on a school governing body. That's what I do within the context of the family law, Gauteng Family Law Forum that I'm part of. We work as a team. That's what we do.
My second question, there appears to me that there is, and now I go to your area of specialization, which is family law. There appears to me that there is some jurisdictional war on Rule 43 applications in Gauteng and in KZN. I've read recent cases from KZN where judges there, I mean, one judgment really shocked me. Where a Rule 43 application was struck off the roll because it had 47 pages. And the judge said it was struck off the roll based on prolixity. And the judge did not go to explain to us what will then be acceptable number of pages. But I know for a fact in Gauteng that the pages of a Rule 43 can go up until 500 pages, if not more. What is, in your view, the proper way of adjudicating Rule 43 applications when a judge feels like, but I've been given too much paper to read?
Prof, as you know, in Gauteng, there's the mandatory financial disclosure form that has to be submitted. That form contains a myriad of information and calls for lots of information and copies of bank statements and the rest. In matters where finances are at play, where it's a question of maintenance. The difficulty in having to condense facts for litigants is the long-term effect, potential long-term effect that any Rule 43 order may have. And as a presiding judge in that court, I was fully aware that I had to accept a bit more than perhaps they would in Natal. But to put a number to what is enough, when is it too much? It's very, very difficult. And it becomes overwhelming in family court to read all of that and to have to distill what is important in that, well, it's no longer files full of paper, it's case line full of paper.
No, thank you very much. And parties play hide and seek and catch me if you can and all those kind of things. Thank you very much,
Thank
CJ.
you, Prof. Thank you so much.
Liebenberg, you're excused.
Thank you very much, CJ. Thank you, Commissioners.